morning, everyone, distinguished guests, esteemed faculty members, and dear students. May Almighty blessings be upon each of us today, guiding our hearts and minds as we engage in this gathering. Let us begin the event with a prayer.
कुरुध्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरुध्वं कल्याणम् आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तुते दीपज्योतिर्नमोऽस्तुते कुरुध्वं.
It is my privilege to welcome you to the national webinar on A Journey of Progress and Promise, 75 years of the adoption of the Constitution of India, on e-platform of Faculty of Law, GLS University. Faculty of Law, Fostering Excellence in Legal Education, is an ambitious venture of the Gujarat Law Society and a premier destination for students interested in establishing a virtuous career in law and aiming to become torchbearers of justice. The untiring contribution made by Faculty of Law has enabled the college to secure a position in Forbes' Legal Power List 2020 as one of the most promising and top law schools. As we convene and commemorate this significant milestone, we reflect on the profound impact of our Constitution on the nation's trajectory. The Constitution of India has been a cornerstone of our democracy, enshrining the principles of justice, liberty, and equality. As we navigate the complexities of our nation's progress, it is imperative to engage in informed discussions and reflections on the Constitution's evolution, challenges, and future directions. Over the course of this webinar, we will have the benefit of insights from renowned experts who will share their perspective on the Constitution's significance, its role in shaping our nation's development, and the way forward. I would like to express my sincere appreciation to our esteemed guests, panelists, and Faculty of Law, GLS University for their contribution to this event. Without further ado, let us commence the program. Now, I would like to invite our respected Vice Director, Ma'am, Dr. Sneha Shukla at Faculty of Law, GLS University for her welcome address. Ma'am, over to you.
Thank you, Aditi. Respected Dr. Vivekananan Sir, Vice Chancellor, HNLU Raipur, Dr. Shilpi Sharma, Head of Department, School of Law, Auro University, Surat, Dr. Sairam Bhatt, Professor of Law, National Law School of India, University, Bangaluru, esteemed faculty members, and dear students. A very good morning to each one of you. It is my honor and privilege to welcome you all to this national webinar organized by Faculty of Law, GLS University, on the momentous occasion of celebrating 25 years of the adoption of the Constitution of India. Today, we do not merely mark a historical milestone, we honor the spirit of our republic. On 26 November 1949, the Constituent Assembly gave India its guiding document, a visionary constitution meant to transform a newly independent nation into sovereign democratic republic. From serving 300 million citizens then to guiding over 1.4 billion Indians today, our Constitution has remained an enduring symbol of justice, liberty, equality, and fraternity. It is the world's longest written constitution, robust in content, yet dynamic in spirit. Every word was written with deep thought and reverence. The making of the Constitution is a saga of commitment, intellect, and idealism. 165 days of intense debates, members of the Constituent Assembly engaged in rigorous discussions to craft a document that would outlast time and turmoil. Dr. B.R. Ambedkar, the chief architect of the Constitution, rightly remarked, however good a constitution may be, if those who are implementing it are not good, it will prove to be bad. This powerful statement reminds us that the true strength of the Constitution lies not only in its text, but in our ability to live by its values. The Constitution has weathered change, witnessed over 100 amendments, and yet never lost its foundational ethos. It has responded to the challenges of modern governance, digital transformation, gender justice, environmental protection, and more, always evolving, never compromising. Today's webinar is not only a celebration but a reflection, a moment to revisit the journey of this magnificent document that continues to bind the most diverse democracy in the world. We are truly privileged to have with us today three eminent legal scholars whose work and wisdom continue to uphold and enrich the constitutional discourse in our country. We eagerly look forward to their insights, which will illuminate not just the legal contours, but also the moral and philosophical depth of the Constitution's journey. Dear participants, let us remind ourselves that Constitution is not merely a legal manuscript, but a moral compass, a social contract, and a shared aspiration. It is not a relic of the past, but a conversation across generations, resilient, evolving, and inspiring. May today's deliberations renew our commitment to constitutional values and deepen our understanding of the principles that shape our democracy. Let this journey of 75 years be not just a celebration of how far we've come, but a solemn vow to carry its promise forward. Thank you once again. Jai Hind.
Thank you, ma'am, for the warm and gracious welcome. It's my privilege to introduce the guest of our first session. Having keen interest in academics, Dr. Shilpi Sharma left legal practice in 2010 and joined law teaching. She is presently working as the Associate Professor and Head School of Law in Auro University, Surat. She has a keen interest in the constitutional matters and teaches the same. Dr. Sharma has published 18 research papers and 3 books, among which one of her book titled Law and Emerging Issues, Taylor and Francis Group, is Scopus indexed. She has also shared her experience and expertise with the member of other educational institution, where she is being called from time to time as a resource person. Dr. Sharma has completed a minor research project on socio-political determinants of NOTA, a study with special focus on the state of Gujarat, funded by the HNLU Gandhinagar. She has developed and offered the courses Federalism and the Federal Structures, that is interdisciplinary in nature. Dr. Sharma is a well-known academician and researcher in the field of constitutional law, and we are privileged to hear from her today on the theme Residuary Powers under Indian Constitution. Over to you, ma'am.
Thank you, madam. So first, I am very honored that I have been given this opportunity to speak on a topic. And I will be here covering the topic in terms of the center-state relationship that is there and how, in what form the center-state relationship is formed and described and detailed in our constitution. So when we talk about center-state relationship, it also tells that what type of federal structure and federal system is established in our constitution and how it is shaped by different interpretations from time to time. So if we talk about the federal system, that is the distribution of powers between the center and the state, it can be discussed in 3 terms. There may be the distribution of legislative powers, then there will be distribution of administrative powers and financial powers finally. So when we talk about the distribution of legislative power, because we will be covering only this aspect only, it has the distribution in terms of territory and the subject matter. So if we go to subject matter, we are having in the 7th schedule 3 lists: list 1 union, list 2 state, and list 3 concurrent list. And then we have the residuary powers. Now I think the students of law will be knowing what the residuary powers are, but in short, I am explaining that residuary powers are those powers which are not mentioned in either of the 3 lists. So these residuary powers are placed, and it is contained in Article 248 of Constitution. Why studying residuary power is important? Because whenever we assess a federal system, the residuary powers and how they are placed plays an important role. So a federal system is assessed in terms of how residuary powers are placed there. If we go to the Constitution of US and Australia, the residuary powers are placed with the state. If we go to India and Canada, the residuary powers are placed with the center. So we have in Indian constitutions many other provisions which shows that our federal system is a little centralized federal system. Residuary power will also help us to study how the system is centralized, but how the autonomy of the states are also preserved. Because the essence of the federal system is that the autonomy of the state should be preserved, whether it is centralized or not centralized. But if the autonomy of the state is preserved, it is a federal system. We should not judge it in terms of what the provisions or comparative study with the US Constitution. So in India, the residuary power, as I said, is placed in Article 248. So before we go forward, we should see what contains in Article 248. I'm just reading out for reference what contains in Article 248. It says Parliament has exclusive power to make any law with respect to any matter not enumerated in concurrent list or state list. That means the power or the list or the entries that are there, that they are not in the state or the concurrent list. Now the Parliament will get power to legislate on those matters. It also such power shall include the power of making any law imposing a tax not mentioned in either of those lists. So taxation matters are also included in that. Now this Article 248 is supported by entry 97 of list 1. And if we go to the entry 97 of list 1 and the language therein, we will see that it is in support of what is written in Article 248. So it here says that any matter not enumerated in list 2 or list 3, including any text not mentioned in either of those lists. So here in Article 248 and in entry 97 also, which is there in list 1, we see that the power to legislate in residuary measures are contained with the center, but both the articles are saying that those powers are only the powers which are not mentioned in a state list or the concurrent list. So in principles, these two provisions are speaking about the autonomy of the state, which should not be touched as long as the entries are there in list 2 and list 3. Now, the residuary powers from time to time has been interpreted and analyzed by the court, and how the jurisprudence of residuary powers developed and how the courts have interpreted or redefined and redescribed the center-state relationship while analyzing and discussing on the residuary powers that are there. So we will be taking up certain important cases with the help of which we can throw some light that how residuary powers are placed in our constitution and how they are interpreted by the courts. I would draw the attention of the audience to the case of Hari Krishna Bhargav versus Union of India. It was in the year 1966, where certain provisions of the Income Tax Act were in question. Now, Income Tax Act have the validity from entry 82 from the list 1. But there were certain provisions which were not supported by entry 82 of the list 1, and those provisions were in question. Now, in defense, it was said that those provisions which are not supported by entry 82 can be included there with the help of entry 97 of list 1, that is the residuary power. The question here arises that if a very clear-cut subject matter is specified in list 1, can another entry from the same list can be used in a same statute or not? Now, here court said that unless and until the second entry is from the same list, and that too from the list 1, that is the list for the union, it would not be in question. The parliament can use 2 entries at a time and enact a law on that. Now, here we should remember that in question was only the center list and the 2 different entries. The important being that out of the 2 entries, one entry was entry 97, that speaks about the residuary power. Now, here also, we should see what is the minority opinion in this particular judgment. The minority opinion was saying that if we are going to entry 97, first we need to establish that there is no entry of such kind in any of the 3 lists. Then only we can go to entry 97, even if we are using 97 with one another entry from the same list. Now, this case is because it is analyzing and interpreting only the union list. It is not touching upon the status or the autonomy of the states. The minority opinion actually reinforced that the autonomy of the state should not be touched. We can use 2 entries, but the autonomy of the state should be preserved. Now, this case was later supported by one more judgment in 1970, that is second gift tax officer versus T.H. Najrat. The important judgment that needs to be seen here is Union of India versus Harbhajan Singh Dhillo, that reshaped the concept of residuary power. Now, it is very important to see in very brief what were the facts so that we can understand that how that residuary powers were interpreted and how the center and the state relationship were redefined. Now, there was a Wealth Tax Act that was enacted. It was amended in 1969, and in 1969, agricultural land was also included in calculation of net wealth. Now, this amendment was challenged, and the grounds were because the agricultural land and the tax can be imposed under entry 49 of the list 2, that is the state list. So here the entry from the state list also comes in question. And this amendment and the wealth tax was having validity from entry 86 of the list 1. Now the question was that whether this act and the amendment falls under entry 49 or entry 86. 49 from list 2, that is given to the state, and 86 from list 1, that is from the center. So here the entry from list 1 and list 2 comes into question, and how these 2 lists from 2 different 2 entries from 2 different lists can be used for a particular legislation. Now, it was also the issue, even if it falls under 86, even if the entry from the list 2 is not in question, does it takes the matter beyond the residuary jurisdiction or not. So in whatever way the amendment was drafted, is it allowed, such provisions are allowed under residuary powers or not, because these are specifically mentioned under 86, entry 86, that is in list 1. Now here the court has interpreted residuary power in a way in which it was not interpreted earlier. Now what the court has said here, the court said that entry 97 starts with the words any other matter. We had seen earlier the language that was used in entry 97, and it starts with any other matter. So the court said that if we use the terms any other matter, it gives entry 97 and the center some additional powers. So here the supremacy in terms of legislation of the center was established by the court. Here we can see the inclination towards center when we speak about the center-state relationship, which is very much there in other provisions also. But here the court said that entry 97 is having additional powers. It is giving additional powers to the parliament to legislate. And what need to be seen, that the subject matter was not included in list 2 and 3. Now, there were earlier cases where it was said that we have to see that the subject matter is not included in any of the 3 lists. Then in principles, in the plain understanding of the residuary powers in any of the constitution, its plain meaning is that the subject matter is not listed in any of the list. Then the residuary powers comes into picture. Here the court said that we have to see only the list 2 and 3. The list 1 should not come in the question. Now here the court is given new interpretations to the matter of residuary powers, and here the autonomy of the states comes into question. So here it is said that if here the matter was in the state list also, but the court said that if we are having the legislation made with the help of union list and also with the help of entry 97, which gives immense power and to the parliament, we can only prove, or we need to prove, that the entry 97 is applicable here, along with some more entries from the same list, and the parliament is having power to make list. We may see that it is not falling under list 2 and 3, but then if it is there in the list 2 and 3 also, entry 97 is giving the parliament immense power. Now this judgment was being criticized later. It is not overruled, but it was criticized. The court recognized that there is a need to now redefine the residuary powers and need to establish the state autonomy also. We can see the judgment of Satpal and Company versus Governor of Delhi, which although reiterated the principles that was given in Dillon's case, but it also observed that residuary powers, whenever it is being used, it should not be used to destroy or belittle the state. The state autonomy has to be preserved and has to be seen. The same thing was again repeated in International Tourist Corporation or State of Haryana, where the court said that we should go to the residuary power when no option is left. So here the court meant to say that we need to return to the situation where we need to see whether the subject matter is in list 1, 2 and 3. If not there, then we can resort to the residuary power. It also said that a broad interpretation of all the entries in list 2 should be done. Now here we can see that court is suggesting what has been done in the Canadian Constitution. If we go to the Canadian Constitution, why I am referring Canadian Constitution? Because in Dillon's case also, the Canadian Constitution was referred and mentioned. Now, what happens in Canadian Constitution? Section 91 and 92. Canadian Constitution is in the form of British North America Act 1982, and it has Section 91 and 92, which speaks about the distribution of power. Now here, residuary power are also mentioned under Section 91. It is given to the center. But what has happened with the Canadian Constitution, that the Section 92, that is the state list, has so much broadly interpreted that the mention of the residuary power in list 1 is just become superfluous. It is there only, but it has put its efforts in maintaining the state autonomy. We have certain few cases where the question where the state list and the entry there was in question. We have many cases where the entries in the list 1 was in question and not from list 2. And we have certain cases where what is the intersection between two entries in two lists are there. So the court has suggested that we need to broadly interpret the list 2 and all the entries there. Here in this case, entry 56 was in question. And then we need to see that the state autonomy should not be disturbed and the residuary powers are used as a last resort. Now, we must see, or we must understand why these issues with the residuary powers and its interpretation have arisen. When we see the language in which the lists are drafted, if we go to the list, we are having a particular technique of writing there. You can find certain entries which are expressly including and excluding certain subject matters. As in Dhillon's case, entry 86 from list 1 was in question. You can find the example in entry 86 only. There can be many entries. If you plainly read the entries that are there in list 1, list 2 and list 3, you can find the language which is including or excluding certain things. You can have certain examples in entry 44, 65, 86 was in question, 92A from list 2, there is an entry 2. So if the entries are defined and written in this way, it may cause certain confusion and ask for interpretation from the courts. And the courts from time to time interpreted and just developed the jurisprudence or the residuary powers, and it's placed in our constitution. Now, there is second reason also, which I have mentioned sometimes back, that we have very little cases where state list is being interpreted. So state list, it was suggested in the case also, it needs to be broadly interpreted. Now, when we see the plain principles or the basic principles of interpretation, it also says that each list needs to be broadly interpreted. We are still waiting. We are not having enough interpretation of the state list yet. We will see how the court in future matters will interpret these lists. And we may have certain more cases where the state autonomy will be established. Now, when we are discussing these residuary powers, it is not so that every time the residuary powers have posed certain challenges and the problem. The residuary powers are also used in some positive aspect also. In some of the cases, the residuary powers has come to the rescue of the state also. I can mention a particular case to give an example. It was Diamond Sugar Mills Limited versus State of UP, where under an act, certain liabilities that was levied under entry 52 of list 2 on the factory were found to be incorrect, as that entity is not coming under the definition of the local area, and thus the act and also the levy was in question. Now, this is not the only case. We can find many such cases where the parliament comes as an emergency rescue. It actually came up with a validation act where whatever was the levy which was challenged and found incorrect was supported, was validated by the parliament, and it is all done through the entry 97 of list 1, that is the residuary power. So it happens many times that residuary powers through parliament has come as an emergency rescue. One more positive aspects of residuary power, that many of the acts which were needed, which were not anticipated earlier, were enacted with the help of entry 97. We can have certain instance, like we are having section 3 of Commission of Inquiries Act. It used the powers that were given by the residuary powers. We have an act for, we can take as an example, Auro Foundation Act that was there in 1988, where government took the management of Auroville into its hand. We had Coffee Posa, we had Consumer Protection Act. It was all supported by entry 97 of list 1, that was the residuary power. So concluding the concept of the residuary power, I can say that residuary powers in its plain meaning means that parliament can have a certain powers, which is very well established that our federal system is having a centralized tendency. But on the other hand, with the help of the interpretation of the state list and the matters that comes before the court also will take in future certain steps to preserve the state autonomy, so that the federal system will be a balanced federal structure in our country, and there will be interest with the law students if they research more on the concept of residuary powers, how they are interpreted, how they are mentioned in other constitutions, a comparative study of interpretations in India and the other constitution, and how the residuary powers can be taken to explain the type of federal system that we are having here in India. So I will rest my talk here and would love to answer questions if there are any regarding this topic.
Sure, ma'am. We'll be taking a couple of questions. Ma'am, few I have asked in our personal emails and this thing, and few have put up on the this YouTube format. So the first question that is there by Palak Mishra is, how has the judicial review been instrumental in the protection of fundamental rights? Could you provide a specific example where a Supreme Court's intervention through judicial review or social justice that has we just need the student needs an example on that, ma'am.
Okay. So judicial review in terms of the protection of fundamental rights, I think you can get as many examples as you want when you see the judicial review of Article 21 and also Article 19. I think the power of judicial review is mostly used in terms of Article 19 or 21. You can also see how the theory of basic structure is established through the process of judicial review, where in a series of cases, Shankari Prasad, Sajjan Singh, I.C. Golaknath, the right to property was interpreted, and also with the help of Article 13 and Article 368. So if you study Article 21, if you study theory of basic structure and Article 19, you can get not only one, but many cases where the judiciary has worked to protect the fundamental rights. Also, when we see Article 21, we see that some of the directive principles that are there in Part 4 are now converted to the fundamental rights under Article 21. Like we can talk about free legal aid, right to livelihood, the environment and its protection, having the safe environment, it is also converted to fundamental right with the help of Article 21. I think Sairam sir is expert in the area of environment. He may be speaking on it. So I'm leaving these things to him only. But if just read Article 21, its interpretation, Article 19, its interpretation, you will get a number of examples here.
Ma'am, one more question that is there. Khyati Thakur is asking, could a future constitutional amendment potentially redefine or limit residuary powers? And what would be the arguments for and against such a move?
I don't think so, because residuary power it itself is not a problem that needs to be so that we need an amendment or so. Residuary powers are there to support our constitution and to support us in future where we cannot anticipate a particular area where we can have law. Like we never anticipated that we will be having or we will need the Consumer Protection Act. We never anticipated when we had our constitution that we will be facing COVID and we may need certain laws there. So residuary power itself is not an issue, but how it is interpreted and how it is placed and how it supports the federal system that we intend to have, because we always intend to have a federal system which will be a little centralized. We are sometimes we criticize it when we compare it with the American constitution or American system. So I don't say that there is a constitutional amendment needed, but yes, with the help of the matters that come before the court, it can interpret, and it is in the way, like after Dillon's case, there were cases where it is said that state autonomy has to be preserved. So when it is saying state autonomy has to be preserved, that it is recognizing that in our federal system, because one of the basic principle of the federalism is that the center and the constituent unit, here we can call state, should have certain level of autonomy and sovereignty. If that is being preserved, I think it is being interpreted in the right way, and in the years to come and the more like matters to come before the court, I think it will be later established.
Thank you, ma'am. We have one more question. Krish is asking, ma'am, do you believe a existence of residuary powers primarily vested in the union undermines the principle of cooperative federalism? If so, how? And if not, why not?
No. It is like cooperative federalism, as I see, is a little distinct issue. But okay, let us address it with the help of residuary powers. Now you can see how the residuary powers are being interpreted. So cooperative federalism means that the center and the state should work in cooperation with each other. There are many other provisions where center is having the duty to protect the states, and states are having they're obliged in certain cases to take the instructions from state from center. Now residuary power and its interpretation, as long as it is protecting the state's autonomy, is not in any way like undermining the principles of cooperative federalism. It only depends that how the matters come before the court and how they are interpreted. So I don't think it is undermining. It is there to strengthen the system, and we may go through certain cases where we have seen that the inclination is towards the center, but we should also understand that the type of federal system that was like envisioned for us was a system where certain centralized tendencies will be there. So when the interpretation of residuary powers are keeping balance between the center and the state, I think it is good, and the cooperative federalism will be strengthened. There is no need to fear about the cooperative federalism.
Thank you, ma'am. If you permits, can we take two or a couple of questions? If so, Your
Yeah,
time
yeah,
permits?
sure.
So, ma'am, one of our student has sent me a question on WhatsApp because of there may be some technical glitch. He couldn't post it on YouTube. So he's asking that with the rapid pace of technological advancement and emergence of new challenges like cyber welfare, warfare, or artificial intelligence, or outer space governance, do you foresee increased reliance on residuary powers, or what are the implications of this on today's
Uh,
governance?
uh, I want to admit that I am yet to study a lot about artificial intelligence and cyber laws. So let me have a deep study on that only, and then I can answer this question. Like at present, I can like request if you can have an expert who can like throw light more on this cyber warfare, AI, and all. So yeah, I'm just a learner in this field.
Thank you, ma'am. One more. We every one of us are learner, ma'am. In law, nobody like can. We all are learner at every stage. So, ma'am, one more question, if you permit. Ma'am, Vishwa Jagida is asking that what is the role of a judge in ensuring a fair trial?
You can see the concept of natural justice. And here, when we speak about the three principles of natural justice, the role of judge also comes into it. So when we talk about the reasoned judgment and audio altum partum, the role of judge is there. So just go through the principles of natural justice. The judge is in the center of all these process.
Thank you so very much. There are few questions, but I think a few of them are like repeating. Like somebody's asking impact, like the how do you residuary powers impact the balance of power between union and the state in India's federal structure? So I think that is already been answered, and there are few which already is been answered in your speech as well as in this question answer session. Thank you so very much for being with us, ma'am, and accepting our invitation, sharing your, insightful sessions and knowledge with our students. Thank you so very much, ma'am.
Thank you, madam, for calling me. Thank you very
Thank you.
much.
Aditi, ma'am, over to you.
Ma'am, just a question, if I can ask.
Yes,
Uh,
ma'am, please.
can I can I leave this meeting? I
Ma'am,
need to attend one more, but I can be here for some minutes also,
okay,
as you
ma'am.
permit me.
As your time permits you, and whatever it will be a convenient to you, can take action. We just request you if you can join at the end of the session by 1:15 around for the formal vote of thanks, ma'am.
Okay, ma'am.
If it is convenient to you, ma'am.
Okay. Just
Thank
yeah, let me find out how long I can be here.
you, ma'am.
Okay,
It's all
okay, ma'am.
up to your convenience, ma'am. Thank you.
Yes.
Moving ahead with session 2, I would like to introduce Dr. Sairam Bhatt, a professor of law at the National Law School of India, University, Bangaluru. Dr. Bhatt is a respected name in Indian legal academia and co-director at Center for Environmental Law Education Research and Advocacy, SERA, faculty advisor, PACE. Sir, I would like to invite you to address us on the judicial review under Constitution of India. Is the Supreme Court supreme? Sir, the audience is eager to hear from you. Over to you, sir.
Thank you very much. I hope I'm audible. Right. Thank you. Um, I think we are today looking to map the journey of the Indian Constitution, both in text, in context, and in action. And I think the Constitution, when it is in action, we say it's the working of the Constitution as the scheme of constitutionalism, because what is written has to be worked. And who makes it workable? Who makes the Constitution, which is kind of a letter of law, workable? Here is where probably we look at the government, which has three organs: the legislature, the executive, and the judiciary. Now, I think the Indian Constitution has adopted a very important phenomena, like someone in the previous session also pointed this out, is the concept of judicial review. So, in this short session, I would like to pose this, constitutional dimension of judicial review in India. Friends, judicial review is important for many reasons. And we all know that how the Indian judiciary has protected or has been the guardian of the Indian Constitution, especially in terms of the fundamental rights of citizens. And the right of judicial review can be actually found out in various articles or provisions of the Indian Constitution, starting from Article 13, where the judiciary can actually strike down any legislation that violates fundamental rights. There are various such provisions where the Supreme Court has these powers, and I think we call the Supreme Court as the Supreme Court or the apex court, which can actually lay down, rules, regulations of conduct of behavior that is required, because we have the doctrine of checks and balances, and in judicial review we believe that the judiciary will adequately check any uh, unconstitutionality of the legislature or any arbitrariness of the executive. And of course, the judiciary can review judicial action as well with writs like certiorari and prohibition. Now, having said all of these, friends, it is important to understand that in India, as we map this 75 glorious years, I must say, of democracy and constitutionalism, I think the role of the judiciary, especially the Supreme Court of India, has been something that has, kind of transgressed the borders of India. To be honest, judicial activism of Indian courts is something that is studied all across the world, and it's become part of the global constitutional studies. So the Indian Supreme Court has contributed through its judgment some landmark decisions, and I think the way it has been able to protect, the principles of the Indian Constitution, I think I don't see any other court in the world doing as much as the Indian Supreme Court has done. So I think we have to start off with accepting the great contribution of the Supreme Court of India. And I think we must compliment this institution that has had some very eminent legal jurists who have been able to, bring in democratic values, protect citizens' rights, and bring in a sense of, reasonable administration as we speak today. Now, friends, look at judicial review in this context. Uh, when you look at judicial review in India, you can probably put it in three stages. The first stage of judicial review was probably before emergency, and where the judiciary was prima facie looking at its role as looking at the basic judicial review, say for checking the constitutionality of legislations, especially in a federal structure, because the judiciary or the Supreme Court would be asked whether a particular legislation was constitutional or not, whether constitutional amendments could be done, if so, how and what. The second set of judicial review that happened in India post emergency was actually kind of a assertion of the Indian judiciary in terms of its supremacy as the last word on the interpretation of the constitution and the application of the principles of constitution. And hence the movement from just checking legislative action, I think the Supreme Court in the second stage, especially if I can say post the emergency, kind of looked at protection of socio-economic rights of citizens. So I think that was a big change that came about. And I think what happened through 1991, especially in terms of globalization, privatization, and liberalization, was also an important step for judicial action and judicial review that took place. Uh, However, I think from the traditional concept of what judicial review meant, in terms of the checks and balance of the legislature and the executive, these were supposed to be the two broad checks that the judiciary ought to have operated. I think today's burden on judicial review, as we can speak, I think let us be honest in terms of the challenges of judicial review in India as we speak today. So I think the challenges are quite a few, right? We understand the challenges of infrastructure with the judiciary. Um, uh, Courts are going online. There are challenges of number of cases, number of litigation that is happening. There could be challenges of the quality of judges and their judgments as we speak today, and so on and so forth, right? So I think we are very clear that we are at the crossroad of testing the strength of judicial review in India, primarily because the Supreme Court today is called upon to decide various factors that probably earlier the Supreme Court was not so much involved. For example, the Supreme Court was called upon to resolve the Ayodhya dispute. These are challenging, situations for the Supreme Court to step in and decide. There is the Supreme Court was also called upon to decide about the rights of the LGBTQ community. I'm just giving you instances of how the Supreme Court today, in terms of its power of judicial review, is called upon to do some very challenging assignments, tasks, and disputes, and also be the last word on constitutional rights. Right. However, I think the topic that I would like to just focus quickly in the next couple of minutes is to look at the role of judiciary, or look at judicial review, especially with developmental projects. Professor Shilpi was saying, or leading to the fact that I do a little bit of work on environmental law, and I would like to place across to you the challenges of judicial review in environmental actions as a case study to test whether the Supreme Court is supreme. The reason why I say this is today is because the Supreme Court is not only looking at legislations and executive actions, but it is deciding whether a development can happen, if so, on what conditions it can happen. So please note, we had a very interesting statement of Mr. Harish Salve, a senior advocate, who once looked at how the judiciary is manning India's forest, because literally from the T.N. Godavarman case, the Supreme Court is actually the manager of India's forest. And very often than not, either you can be very progressive in that management, or regressive in your management, or very conservative. And this may impact growth. It may impact development. It can impact employment. It can impact so many other factors. And unfortunately, the Indian Supreme Court is dealing with these kinds of matters of development versus environment, and development, and several other socio-economic rights. Now, this factor wherein the Supreme Court is determining economic development and economic growth is where my case study is about whether the Supreme Court is really happening to be really supreme in terms of its judicial review action. Now, to contextualize this, friends, let me tell you that in India, you cannot undertake most developmental activities which are of large scale and which really impact large sections of the community. That could include highways, railways, power projects, or any other kind of activity. Please note, the ultimate kind of clearance that is required for this developmental project is called environmental clearance, right? In short, we call it EC. Now, all companies, all projects, all developmental activities inevitably have to get an environmental clearance, right? Now, this is something that the executive gives. It is something that is given by the Ministry of Environment and Forest. However, the way in which these clearances are given and how they have been administered over the last 30 years has often landed up in the doors of the Supreme Court, right? Now, what do you expect the Supreme Court to do, right? The Supreme Court usually should be there in terms of interpretation of law. It should finally look at resolution of legal principles and doctrines and so on and so forth. But should the Supreme Court also enter the domain of the executive in terms of deciding whether a development work should take place or not? And should it use the interpretation of law to do so, right? And if it decides that this is something that can be part of judicial review and judicial action, then should the Supreme Court be consistent and certain in terms of the anticipation of the rules of development versus environment? These are larger questions that needs to be addressed, because as we progress as a digital country, with so much of digitalization, like someone did say, adoption of technology and so on and so forth, or as we progress towards a Viksit Bharat of 2047, what would we expect? I think if you use the word ease of doing business, if you use the word of being, a progressive nation that is supporting business, balancing environment, and looking at sustainable development, I think judicial certainty, of course, executive certainty and legislative certainties are core and important for any kind of development, but judicial certainty, I think, is the primary basis of progress, right? And I think if the judicial, verdicts are not consistent, certain, and are not, clear, I think businesses will suffer. If businesses suffer, growth suffers. If growth suffers, development suffers, jobs will suffer. The future of this country will also be challenged. So I think these are just the few, impact of this uncertainty. But very quickly, looking at the time, let me just try to share my screen. How do we share this? Yes. Can I share a PPT? Is that possible?
Yes, sir, you can share it. There must be a share a screen or that in the device.
Okay, let me.
Present would be the next.
Okay,
Ma'am,
present.
there is a plus mark, yeah, on the screen.
Share a screen.
Yeah.
Yeah, got it. Right. Just confirm if the screen is visible. Is the screen visible?
Sir, not now. It is not visible, sir. If presentation is not visible to us, sir. Sir, now I think would be visible to us.
Okay, great.
Yeah.
Okay, excellent. Now, ladies and gentlemen, I have just put up one slide in which I have taken about 7 cases that are before you. Now, you will notice that right from 2017 till very recently, in May 2025, the Supreme Court has been called upon to look at environmental clearances. Now, the real issue was in all of these cases, and please note these are all very important cases, because one of these cases becomes a precedent. As we see in the Constitution, whatever has been laid down as judgments, directions, and orders of the Supreme Court are the law of the land. So whatever is said by the Supreme Court then becomes the law of the land. But has the Supreme Court said something that is consistent as the rule of law, especially on environmental clearance? That is the issue, right? Because we expect rule of law in every aspect, and the judiciary's basic duty is to establish the same. So if you see the challenges, and I have also looked at how the Supreme Court and who in the Supreme Court was saying what, you will notice that right from the common cause case, the issue is, of course, businesses should take environmental clearance. But can they start the business, and post starting of the business, can they take an environmental clearance? This concept was called, or continues to be called, as ex post facto clearance, right? So the law, unfortunately, had said that you must take clearance. And in 1994, the first law on environmental clearance was mentioned or brought about, and they made environmental clearance mandatory, and they said it shall be undertaken. But the word prior was not used in the 1994 notification. But in 2006, when a new notification came about, which was called the EIA, or public hearing notification, the word prior was used, which means before you start an industry, you must take an environmental clearance. Now, of course, there were several instances. Let me tell you, friends, the number of industries that did not take prior environmental clearance was humongous, right? And for many reasons. The reasons are not necessarily of ignorance of law, but the reasons are you're not very sure whether your industry is supposed to take an environmental clearance or not. So it is based on certain scientific, technical parameters of whether you're a red category industry, orange category, etc., etc. Right? What is your pollution load, etc. So a lot of industries were clueless about the prior clearance that was required. So what they did, the operation started. They some established a shed, and later on they wanted an environmental clearance, and hence the matter went to the court. Can ex post facto clearances be granted? Right now, the industry has not literally violated or contaminated the environment. It is just about the license that is required to operate. So it is something kind of license raj system. So if you notice, in 2020, Justice D.Y. Chandrachud, in a case called Rohit Prajapati, he said, ex post facto clearance violates the precautionary principle, and hence it's not in tune with environmental principles, and it should not be granted. But later on, as Honorable Justice Indira Banerjee came in D. Swami, in the electro steel case, and in Fawa Plastics case, of course, when you make a rule in India, then you start making exceptions, right? And the Supreme Court said, oh, yes, that could be the rule, that ex post facto clearance generally should not be granted. But suppose the industry itself is for the environment, like a biomedical waste treatment facility. Why shouldn't it be given clearances? See, biomedical waste treatment facility should have known environmental law. They should have taken prior environmental clearance. But still, irrespective of that, if they've not got it, I think they should be eligible to get the same. Then they said a steel plant. A steel plant in electro steel, they said it contributes to the economy, and hence they should be entitled to it, because it was usually environmental clearance is not only required when you start an industry, it may be required when there is an expansion of the same. So you can't shut down industries, because shutting down of industries will lead to loss of jobs and growth and etc. etc. So they should be entitled to a post facto clearance. So if you notice that very recently, coming because of shortage of time, the Vanashakti case, where Justice Abhay Oak, was the one who rendered the judgment, they have now said, look, when the legislature uses the word prior environmental clearance, and the word prior is used 34 times, then it is very clear that the intention of the legislature is to say that you must take clearance before you start. And hence, any concept of a post facto clearance must be done away with, and it should not be granted by the ministry. Now, our post facto clearances now that has come by the Supreme Court, are they granted because there is arbitrariness in it? There is unfairness in it? Does it violate the principle of executive action? And is that the reason that the Supreme Court has said it's the same? So I think in terms of businesses today, while I do a little bit of practice and do a consultancy both for the pollution control boards and for the industry, friends, just on the concept of environmental clearance, there is so much of judicial uncertainty. Companies simply don't know what is the rule of law today on environmental clearance, because the ministry is just bound by the Supreme Court judgment. The Supreme Court judgment now has said don't give any further. So what happens to existing industries? What do they do? How do they operate? Becomes a very important challenge as we go forward. So I believe that it is important for the Supreme Court of India to be the last word on the interpretation and on the application of law. And if that should be the case, I think the Supreme Court has to be far more consistent. It has to be the apex court, and I think it must reason very well about where it should be able to intervene in matters, and where it should allow the executive to operate in their own domain. Thank you very much.
Thank you, sir. Shall we move to the question answer forum, sir? Thank you. Sir, I think the last cases that you have discussed, the Jheel Pujara has a question on that. So we'll take that first so that sync can be maintained.
No problem. I
Sir,
can take the question on my own, no issues. How have the Indian Supreme Court, particularly the Supreme Court, ruled on the legality and scope of? So, Zil, if you notice that my entire slide was on the legality of ex post facto clearance. Okay, so the current position as we speak today is the One Shakti case, and the One Shakti case has said no ex post facto clearance any further. Okay, the two OMs that the MOEF had declared have been cancelled, held void by the Supreme Court of India. But please note, Zeel, environmental clearance is only one part of the entire process. We have forest clearance. If you are doing a mining operation inside the forest, you have to also get a forest clearance. We have another concept called the CRZ clearance. So if you're actually doing any kind of project within the CRZ area, there is CRZ clearance. Does the One Shakti case apply to that? That's my first question to you. The second most important question is, look, this is about clearance. We have to make a distinction between those who contaminate the environment and those who are not able to do compliance. You can't hold both of them in the same zone of being criminals. Right? They are not to be treated in the same context. But of course, many of us will say, sir, that is ignorance of law. Do you expect industries with a big legal team to be ignorant and not take environmental clearance? That too prior. But this is, to be honest, from my own practical example, I can definitely tell you, this is a challenge on ground. Because let me tell you, in what does prior mean? Can I buy land and then should I take environmental clearance, or should I take environmental clearance before I buy the land? Can anyone answer this? Can anyone answer this? I can give you a guarantee no one can find a true answer to this. You know why? Because suppose I buy the land. The land has to be actually not a fertile land. It cannot impact food security. And I cannot establish a red category industry in a fertile land which is irrigated, right? So after buying land, and if I go for an environmental, does it make sense? So the land use planning, or what we call as industrial siting guidelines, are very clearly that have to be adhered before you take an environmental clearance. Because suppose if I take a good land, fertile land, my industry will impact the land. It may contaminate the biodiversity, the surrounding, species as well. So in a National Highway Authority of India case, this was precisely, it is called the Bangalore-Salem Highway project. I think the Supreme Court themselves were clueless. They said, we don't know. The ministry also does not know. So prior word means what, right? So in many cases, the industries have developed their shed. They have put the machinery, right? But they've not started the production yet, right? Are they eligible for environmental clearance now? Is that word prior in that context? So I think these are factual challenges that we see on ground and in reality. And the same went to the court. See, in the D. Swami case, it was a biomedical treatment plant that was running for 3 years. Honorable Justice Indra Banerjee said, look, it is for the environment. Now, if they don't get clearance, who will process your biomedical waste? So clear them fast. They are for the environment. They are entitled to such a clearance, even if they have not applied for it. So, yeah.
So next question.
There are too many questions now.
Sorry, yeah, we do have
You can probably
at least double digit to indeed like 15 around, but there are some which are repeating in its nature. So we'll have those which are, not.
Okay, so Desai has talked about constitutional assembly debates. I am this session was not about that, so I'm not answering that right now. And ex post facto clearance is a very new concept after the introduction of environmental law, so I don't think we need to look into that. So what are the limits of judicial review? I think that there are many limits of judicial review. I think we understand that, right? But the challenge is, the judicial review in the Supreme Court is never final. From a divisional bench, it goes to a 3-judge bench. From a 3-judge bench, it goes to a constitutional bench. From a constitutional bench, it can go to a curative petition as well, right? So I think that kind of review is something that is also something that becomes a challenge, and that is adding to the burden of the courts. It's easy for us to sit here and criticize about the review within the Supreme Court, but I think it has helped bring about a greater degree of justice. I still remember a curative petition on a contractual dispute of DMRCL, the Delhi Metro Rail Corporation, with the Airport Express line. It was worth 6,000 crores. Had the curative petition not been done, the government, especially DMRCL, Delhi Metro, would have ended up paying 6,000 crores. So I think in some sense, the end of justice is what the judiciary is attempting to do, and I think we must applaud it. So I am in favor of judicial review and the endless limit of the same. But I'm sure the judges are very cautious about their role and how much they should intervene and where they should not intervene. I think this is precisely the point that I wanted to drive. I think it is up to the judiciary now to decide where they would not want to intervene, right? And I think this is about time that they will start slowly exercising that kind of a limit for judicial. Can the constitution evolve without formal amendments? No, that's not again the topic for the session of mine. No, I don't think any law can be static, right? Even the constitution cannot be static. See, the constitution that was written 75 years back, it was written by my so-called fathers. Does the current generation like the same constitution? Need not be. I think every generation must be able to contribute, evolve its own constitutionalism as the case is, right? Now, for example, I talked to you about the LGBT rights. I'm sure these rights will come. May not be by the current generation of judges, but maybe by the future generation of judges. It could be rewritten in that context. And I'm not just talking about decriminalization, I'm talking of recognition of marriages. Right? It could be. You never know. Let's not anticipate the judicial review of the current generation and impact the rights of the future generation. Right. Anuradha is saying, in a democracy, the legislature is accountable to people. How does judicial review often exercised by elected? Oh, Anuradha, this is a great question. How do we hold accountability of judicial review? I think that's what Anuradha's question is. I think that's a great question. I think, see, let's understand that accountability can be direct, and that's what the legislatures face once in 5 years. It could be indirect. Today, as we speak, the fourth pillar of democracy, that is media. Does it hold the judiciary accountable? Now, please, I think it does. Today, with online virtual hearings, you go to any newspaper, every page has some judicial review that's happening, right? Today, the Bombay blast, train blast, so many people have been acquitted in that. The journalists are holding judges answerable, accountable by writing in the press. So I think social media, if it's responsible, can hold the judiciary accountable. Yeah. So let's not forget that accountability of the judiciary can be indirect. It is actually happening today with a lot of transparency and accountability from the judiciary. For example, we have Right to Information Act, Assets and Liability Declaration, so on and so forth. So I think the judiciary is also trying to understand that while direct accountability does not exist, indirect accountability, I think, is far more stronger, and we may have the first impeachment. You never know, thanks to the fourth pillar of democracy. Yeah, which other question do you want me to take? Okay. Judicial overreach is okay. I perceive that judicial overreach is again a kind of an expression to hold the judiciary accountable. I think while we accept judicial activism, judicial overreach is where the judiciary has to be cautious about, right? I think it's an expression that need not be much used, but I believe that the judiciary has now laid down certain guidelines about public interest litigations. Otherwise, it was getting flooded with number of PILs. Who can file a PIL? Because just by dilution of locus standi doesn't mean anyone can approach to the courts, right? This is first thing. Second, I think one thing that the Supreme Court obviously has to understand, and I'm sure it does, is the role of the high courts, right? I think high courts are also constitutional courts. They can also make important constitutional decisions. And I think we must believe in the strength and quality of judges even in the high courts. Right? So I think the Supreme Court kind of has to appreciate and understand that kind of distribution and delegation of power. And I think in India, the Supreme Court is doing a fantabulous job, and that's why it has become a kind of a role model for the judiciary of the world. Right? So on a very positive note, while of course we can always talk about the various negatives that are there in India, often we focus on the negatives. Let's focus on the positives as well, and the great takeaways. The fact that we all have the freedom of speech today, and the freedom of fair criticism today is thanks to the Indian judiciary. So I think in that sense, Judicial overreach is a cautious tone, but I think the judiciary knows where it has its own limits.
Thank you so very much, sir. There are the questions in the list, but I think most of them are repetitive or has been covered in your speech. Thank you so very much, sir, for being with us and sharing such a
My pleasure.
thought-provoking session.
My pleasure. I'm sorry, it's an extension of 5 minutes. So,
No,
uh,
absolutely not, sir.
Vivekananan,
It was
apologies.
like a perks to us that we got to know many more aspect on the topic, sir.
Thank
Vivekananan sir also has joined us. Sir, we request you. Good afternoon, sir. Sir, we request you to unmute yourself.
Yeah, I said
Yeah.
good afternoon to all of you and also
you.
to Professor Sairam.
Sorry, sir. 6 minutes extra, sir. Borrowed from you.
That is de minimis for a professor. Right.
Over to you, sir. Thank you very much.
Sairam, sir, thank you so very much. We request you to join us back at 1:15 or likewise we'll met. Thank
I'll
you.
excuse myself for another session. But thank you very much. Yeah. Bye.
Thank you, sir. Sir, we welcome you, Vivekananan sir. Over to you, Aditi ma'am.
Okay.
It's an honor to welcome Dr. V.C. Vivekananan, sir, Vice Chancellor, Hidayatullah National Law University, Raipur, Chhattisgarh. Vivekanandan sir's work in the legal field is both vast and impactful. Sir is a senior legal academic with over 30 years of experience in teaching, research, and leadership. He has served at NLSIU Bangalore, Nalsar Hyderabad, IIT Kharagpur, and was the founding dean of Bennett University's School of Law. A specialist in intellectual property and internet law, he has held the MHRD IP Chair 2008 to 2017, represented India at WIPO SCCR meetings, and contributed to ICANN as an ELEC and NOMCOM member. He founded the Legal Information Institute of India and led innovative legal education initiatives at Nalsar. Sir has been a visiting scholar in Europe, Japan, and US, serves as a National IP Award juries, and is widely published. His interests include music, cinema, and travel. We
Thank
welcome
you.
you, sir, and I request sir to kindly deliver his address on Constitution and IP protection, a 75-year retrospective. Over to
Thank
you,
you.
sir.
Thank you. I hope I'm audible and clear enough.
Yes,
Right.
sir.
Right. Okay. So, first of all, it's a pleasure to associate with your institution, which I've done in the past, and I'm quite happy to join you today for this short session, which you have indicated to speak about 75 years. As I said, 75 years, an audit in terms of 30 minutes is a onerous task. So I thought I will put it this way, in the sense, as I always believe that it is the critical issues which really is important, because what is good is always with us. There's nothing much to worry about what are good things. I do tell people, when you are moving forward on any aspect of life, think about what is the problem or weakness rather than your strength. You don't need to rejoice strength, it's always with you. It is the problem of weakness or issues which needs to be addressed so that our strength continues. Otherwise, the strength becomes a bit illusionary in a way. So I thought I will focus on few aspects which I consider at the 75th year, or rather, what is the half glass full is already full. What needs to be filled up in the remaining half glass is what could make some kind of meaningful gesture for the listeners and also the co-learners. So, if I start little formally, we are talking about constitution which was in the making from 26th November 1949 which culminated in 26 January 1950. Those who are statistically fond of data, it is 2 years, 11 months, and 17 days, which took to put up a document which at that point of time supposed to govern 40 crore people, and today we are talking it covers an ambit of 140 crore people. So naturally speaking, the challenges have to be much more than what was envisaged at the time in the 50. Nevertheless, however big the challenge, if there is a spirit to work the constitution, then no challenge is insurmountable. If I have to quote none other than the architect, Dr. B.R. Ambedkar, he aptly told in his final address with a sharp insight, which all of us have heard this, and it is good to hear again and again, that, quote, however good a constitution may be, it is sure turn out bad because those who are called to work it happen to be a bad lot. And very recently, Supreme Court echoed this. And nothing wrong, we need to keep echoing this cautionary statement that it is not the theoretical, wordsmiths which put the constitution, what actually happens in practice, which is the art, which is the dynamism of various stakeholders, including law teachers like us. So this is a powerful reminder from which we should really talk. When we talk about 75, I would like to touch upon certain core aspects or important aspects. First one, I would say the core constitutional value. What are the triumphs and trials? If I look at the core constitutional value, justice, social, economic, and political. And these are the three things which we are focused. It is when often the debate is what is justice. If you ask a classroom of 60 people, then there may be 60 interpretation and the teacher will have their own interpretation. But end of the day, all of us does have interpretation, but it is focused on three aspects, which is human life. One is social, we are social beings. Then economics, that is what it moves, not just our thought process makes us live. And political, which simply means which is the most civilized way of resolving the differences, disputes, and move towards a goal. So these three mantras, social, economic, and political. If I take it as how this is being played out, I would like to even quote a recent case, that is state of Gujarat versus Parmar Avinbhai Nanjibai in 2023. The Supreme Court in this case emphasized justice must be inclusive, accessible, and not delayed. It reiterated the maxim again, justice delayed is justice denied. So why I bring this a very recent quote, it is an unfinished task. You may scale up, but you may slide again down. And this is the dynamism of human society and human life, or dynamics of any nation state. So it is very, very important that we are talking about inclusive, accessible, and justice which is not delayed. The preamble, which faces social, economic, and political, has delivered landmark. I need not tell law students who are seniors or who are just juniors joining that Keshavananda Bharati case in 1973 and Maneka Gandhi case in 1978 are two important things which we have to again read like mantras even till today. And when I talk about social justice, the early discourse was mostly on caste-based discrimination. Much little later, thanks to a lot of development, gender became a center focus, right? Gender-based violence and social exclusion. These came and this continue. We read newspapers, we read many cases coming to the court, however swiftly we try to resolve the matter judicially, but these are definitely plaguing the society, which means the constitution is there as a guiding light, but are people taking the right guidance, or we are still groping in the dark? Articles 15 and 17, apart from that, still we know caste atrocities persist. And comes a new scientific evidence which was hitherto based on certain level of opinions or certain level of imagination is the issue of LGBT, which today science has proven it is not God's curse, it is not what you call as some kind of funny aberration, it is a DNA, it is a chromosomal aberration which has led, and those people also have a right for a legitimate as well as decent place in the society. And this very late in Indian context, but nevertheless it's acknowledged. Younger generation understand it far better than the older generation, who may have difficulty to understand when they are talked about sex as a binary concept. So this is a very crucial challenge, I call it, when 75 and beyond, when we are looking. Economically speaking, India's wealth disparity is definitely staggering. Top 1% holding 40% of nation's wealth. Informal workers lack social security, and unemployment is still rampant despite Article 4.1. We may give statistics so many employment generated, but your population growth and the matrix is very big. So obviously you will find, and let me tell you, if economics is not concentrated and then brought to a level which is which is something acceptable, your foundation of social and political things will crack. What results generally of this not concentration on economic delivery, not in terms of gross numbers, but in terms of equity, in terms of various strata, could result in the gain what you have gained in 75 years could be squandered very fast. So economic thing, not just total GDP, not in terms of the number of millionaires, billionaires, which is all, funny statistics, but we are really talking about a meaningful life for every citizen. And that is a crucial part when you are really talking about constitution. Then politically speaking, well, we do have good statistics. 5-year peaceful change of power. There has not been violent overthrow, and still there is a lot of civic sense. In spite of bitter fighting in parliament or outside, people greet each other. People, have their pleasantness to, what you call as appreciate many things. And if there is a big political leader's death, whether it is a regional leader or a national leader, people converge, people forget their thing. That's all fantastic gains. But over the period from 50s, 60s, 70s, money power has entered, and also very opaque electoral funding. These are threatening the ideal of a fair representation, or again, representation of marginal communities are still inadequate in spite of working on quotas, other things. The reality is that it is inadequate. The underutilization of Article 39A, which promises free legal aid, is a serious concern. The judiciary is already overburdened with 4.5 crore pending cases. Then strengthening legal aid and simplifying procedures and investing to an extent which is an affordable and accessible digital justice are the one which can bring in some kind of reprieve of this humongous pending cases. So 39A is a very crucial thing to work. In a recent case, I would like to quote Kaushal Kishore versus State of Uttar Pradesh, again in 23, the Supreme Court upheld the right of freedom of speech as a public functionaries, but cautioned against hate speech. So we are really talking the political landscape needs a very careful balance between freedom of expression and something which is a motivated hate speech. So nobody still has the formula, and the debate is still going on. Sometimes some Supreme Court judges are criticized, some people are welcome about where do you really bring out a reasonable balance between freedom of speech and hate speech, which can spiral into physical violence. So the judgment underscored between 19(1)(a) and the remaining, freedom of speech articles of public accountability. We are still grappling, probably that we will come to some level of understanding by legal scholars in academia as well as judicial pronouncements. And coming back to another area of constitution, especially in a country like us, which you can count every religion in the world having some presence in this space called India, and the language and the diversity what we have maybe never be understood by some other countries which more or less have a kind of a monolithic religion or monolithic language. So the question always is it a strength or is it a challenge? In my opinion, India, to be distinct from many other spaces, this diversity is the biggest strength. And in such case, it is I would like to say that what you call as we need to really look about how faith, belief, worship is preserved. At the same time, it does not hit somebody else's belief, somebody else's faith and worship. It's a very tricky thing. It theoretically we can formulate many things. In practice, there is over enthusiastic, overzealous in every faith, in every worship and every belief. So this is very important. So Article 19 to 22 is very crucial and central to the 75 plus roadmap what we are really looking. The expansion of the article to include right to privacy, reproductive autonomy, and clean environment in the recent times has been a great contribution to the interpretation and expansion of Article 21, how liberty itself has been strengthened as a very crucial point. However, we also have on the other side misuse of sedition laws, and then unlawful activities prevention act, many of them which were brought with certain intentions, but in the real power play it suppresses dissent. Arrests of activists with legitimate expectation, students who have the legitimate expression, and journalists who do a great job many a times of, as a mirror to what is happening of the power misuse. They are in the recent times finding a very shrinking space, and so that I call it 75 plus. In this space it's a worrisome thing. So internet shutdowns, especially when smallest trouble in a state, we do internet shutdown. We just not disruption of some communication, but you should know internet today more than communication, it is livelihood of people. We know the kind of digital commerce. A coconut seller is dependent upon a digital platform to run his business. So it is no more the luxury of our mind and speech. It is our day-to-day essential. So we need to really calibrate these shutdowns and other things, which has been done many a times at a knee-jerk reaction. So also surveillance concerns. There are sophisticated software, and as AI is increasing, the sophisticated software can even do a brain mapping, in terms of your neurons to tell whether you are plotting or rebelling. And this kind of misinterpretations can also happen, which means you are not able to tackle technology, but your constitutional provisions to safeguard the much cherished liberty is very important. Uh, Justice D.Y. Chandrachud remarked in one of his discourse, a mature democracy must engage with dissent, not to silence it. So the word is engagement, not what you call as living in a denial mode. Then if I take another one is what is what I call as rule of law, and is there equal protection? If you go to 14 to 18, state shall not deny any person equality before law. This has been reaffirmed in the recent times, which is a affirmation for 75 years of democracy and constitution moving in the right direction. Decriminalization of homosexuality, Navtej Singh's case, and striking down of adultery laws, Joseph Shine versus Union of India. These are well thought judgments which will go a long way. There may be votaries for it, There may be votaries not comfortable or opposed, but let me tell you, courts just like that don't come out with certain whims and fancies. They slowly and steadily open up, certain vistas for a different type of thinking, a different type of accommodation, different type of a diverse space for many people, without affecting others. So in spite of all this, what I call equality of law in terms of individual way which society looked at people, but group wise, Dalits and Adivasis continue still to face social and economic exclusion. It might have reduced what it was 30 years, 40 years back, but it should have no place in modern age. But shockingly, every time one or the other report will tell, it operates in a very surrogate way and silently. So this is one. And nevertheless, to tell about gender parity, it is, in my opinion, it's a very, very distant goal. On one side, a kind of worshipping the women as goddess in a big way, but the other time, when it comes to regular life, the goddess vanishes. And so, in spite of 3 decades of talking, one third, not even 50%. Remember, population has 50% men, 50% women. They are only differentiated by certain nature's creation of physical difference. But I don't think so. You take the brain of a woman and a brain of a man and then analyze. There's no difference at all. No difference in terms of performance, functioning, and efficiency. But this is a structural problem. So today also we have less than 14% in parliament, the women legislators. This is definitely, I would consider 75 plus, it's one of the big failure. And something needs to be not done, it should be done urgently. So the debate or the scope talks about also creamy layer, all that stuff in order to benefit others. And when we talk about equity, liberty, all that, we also have a specific area called Northeast, right? Northeast, certainly, you know, uh, a lot of things are, being focused, but you really find still they cannot come into the mainstream in many ways. It has nothing to do that people don't want to come or anything. Certainly, there is a functional deficiency in terms of trying to bring them as part of this. And this will be a challenge after 75. If I take a couple of more points to flag 75 years, that is plus and minus, then we are talking about dignity of individual. And as I told you, as we speak, hate speech, identity based violence, online abuse, honor killings, caste based lynchings, and polarized political discourse is one which fractures the idea of fraternity, thereby negating the main purpose of the Constitution for a society which is egalitarian, a society with dignity, with everyone to live in peace and according to their will. The, we found this requires not only constitution provisions, but a cultural and political will. I call that, as I said, cultural and political will of the society. Cultural will, which is social. Political will, those who represent us should be leading examples and models, putting these things. These two are crucial in terms of liberty, which is one of the strong pillar of constitution, Indian constitution. If I come in the from the top down to bottom up, then take it as a horizontal thing. One of the issue which we need to really focus in 75 beyond is federalism. How is federalism and the institutional things are balanced? Are we consolidating, or in the name of consolidation, are we centralizing? Articles 245 to 263, if you look, a cooperative federal structure is what it reads. But the trend, if you see, has been towards centralization, right? Including a more efficient mechanism which was brought by a major political party, earlier implemented by now another party, is GST. And if you look at it, GST, right, volumes of increased, money is there, etc. But you see a huge simmering thing with the states complaining about limited financial autonomy. They find delays in compensation. They find discretionary allocation of the grants. So these are all definitely will have a big challenge to the constitution post 75. Because remember, it is very easy, states have their own identity. People easily identify. Sometimes they cut across political party or ideologies to identify with a particular state, because we were all based on state, based more or less on language and certain other cultural criteria, which was pre-independence. And then we thought the best way is to preserve this for a greater unity. So in such case, this federalism, and if it is not carefully nurtured, will have its issue. And I need not tell, in recent times, the language debates, and is there an attempt to cultural homogenization? This will be definitely not only boomerang, but will have a tremendous problem in terms of losing the consolidation. Right? The consolidation of 75 years will be under severe stress if people take it for very lighter way about factors of language and culture. So true federalism demands equitable power sharing and respect for state autonomy. That is very, very, very crucial, right? So individual to society to states, these all three things becomes an integral part of an audit of 75 plus. And then I come to more touchy area which is being done is constitutional morality versus majoritarian politics, right? So you really find that Ambedkar highlighted the importance of constitutional morality. He said respect for values like rule of law, accountability, and the rights, even when it is unpopular or otherwise, the majority is always not right. Majority could be convenient for governance, but you have the problem of majority as a runaway politics, and which could, stampede the minorities. When I mean not just in the religious sense, it could be in cultural sense, it could be in language sense, in many, many ways. So it is very important that Ambedkar again had the foresight to talk about this. So you find one problem again is constitutional morality. Constitutional offices are increasingly politicized. I'm pretty sure all of us are reading that, even though we know many times there is a clear cut, kind of a link between the office of governor and whichever party is in ruling power. But it had its own do's and don'ts and decency about insulating, but that is quite vanishing nowadays. So it becomes very difficult. A constitutional authority, whether is he a party authority, that kind of blurring is happening in recent times, which is being dealt by what I call as Supreme Court itself. Many a times you see the case of deciding within this time by the governor or president, which is going to be taken up, which is being taken up in Supreme Court today. So you really find the strain and stress is very, very high, even with 75 plus gain. So parliamentary functioning also has weakened. You have very declined number of sittings. You have legislations which are rushed or with minimal scrutiny. So Rohinton Nariman Justice Rohinton cautioned that constitutional morality must be cultivated as a clarion call for all stakeholders. Otherwise, we are not talking 75 plus. So if I put it across, that are we talking about at 75 a transformative constitutionalism where purpose is not just to limit the power but to realize social and economic, thing, what should be the goal. As I would like to, what you call as, stress few points before I wind up. That is, democracy, in essence, thrives on robust institutions. And robust institutions, in turn, is the guardian of the constitution and its value and principles. Judiciary does play a critical role. Election commission as a neutral arbiter, right? And funding, which is a prerogative of well-wishers, should be managed in such way that it is transparent. And these things are very, very crucial in order to, what I call, uh, rebalancing the discourse of what is happening. So if I ask me, is it an evolution or erosion? I would say that 105 amendments so far, the constitution has definitely shown adaptability, which means it is evolution. The 73rd and 24th are grassroots democracy. 86th amendment made education as a right? But at the same time, the 42nd during emergency curb freedom. We only wish that no such thing happens. So, in essence, I would say that 75 years, the gain is certainly on a brighter side. But it is not a rosy picture again, because, as he said, if you don't rework this constantly again and again, one will slide back. One will slide back whatever gains one has received. So, what needs to be done? At least five or six are crucial. Promoting constitutional literacy, civic education is foundational, and probably the program by GLS is in the right direction. Reforming judiciary, right? As much a vacancy in a college, really affects education. Vacancies in judiciary affects, clearances of cases. And electoral reforms, that is, funding should be transparent, integrity, and should have some equity. And decentralizing power, the fourth item, could be to empower long lip service which you are paying to panchayats and municipalities. And then, to cope with the modern age, the fifth point should be digital and environmental rights. And the last point, as I said, all institutions should be restored their autonomy and accountability. And that is where people will have a faith that it is a living constitution. It is not a good calligraphy book, which it adores many of our rooms, including my room. So India rests merely not on the text, but how earnestly and inclusively its spirit is upheld. As we move to the next phase of our constitutional journey, some of the points which I reflect, as reflected by many, will breathe new life into our constitutional democracy. Right? Thank you very much.
Thank you, sir. If you permit, students have asked some question, and if your time
Sure.
permits, we'd like. Yes, sir. So, yeah,
That
this
is
is
the that is the tough part always, right? But let me attempt. Yeah.
So there was a student, Dia, is asking that how can India ensure its constitutional based IP regime foster innovation while promoting access and socio-economic development?
See, the question, if I have a frank answer, being in this field, IP definitely brings economic development. But IP, whether it brings social development, I have my doubt. Because of the simple reason, any type of exclusivity is good for the owner. Any type of exclusivity is bad for the consumer. So it's a tricky question, that the consumer wants everything free and the owner wants everything to be charged, right? And how do I balance this? In such case, the constitution currently is in a correct position. It brings a lot of checks and balance. It is encouraging through patents law, the ability to invent, the ability to get legitimate gains. But in constitution, the right to health and many things very strictly puts the Lakshman Rekha how far IP can go, or incentive versus access. This is the crucial question in before the constitution, before the government. Whereas incentive will be for the owners, access will be for the common man. So it's a very, very tricky society in open markets, in a society like India developing, which has to compete with other countries, also to cater to a huge population. It's really, really a tightrope walk. And so far, so good with Government of India has made the right moves on certain times of compulsory license and few things, and they have done it. So my answer is, it is constitution based already. Because IP is a tool. It is not a fundamental stuff. It's a tool. How do you use the tool? The constitution guides you in terms of fundamental rights, which includes right to health. Right? I think I have given some kind of hint on this.
So the second question that student has asked, it is relevant to this, concept only, that is socio-economic development, where he is asking that how has the balance between private IP rights and public interest, like for example, he's asking about access to medicine, educational materials that is been struck by the Indian judiciary, particularly in light of constitutional principles like directive principles of state policy. Somewhere you already have answered that exclusivity is good for the owner and bad for the
No,
consumer.
I can add a little bit.
Yes, sir.
Let us also have a clarity. When you say private rights, the private dynamism can function very quickly, try to put solutions. Vis-a-vis a public initiative, it keeps circling. It doesn't really reach a goal. Private has the dynamics of identifying, spotting opportunities, how to do. No doubt about it. If vaccines are coming fast, certainly it's private, which is moving in very fast in the direction. So the point is simple, right? The question is to encourage private dynamism, but at the same time, marking the boundaries. It should not be a runaway private dynamism. That is where the role of public, when you talk in constitution role is a gatekeeper of many things. So it does allow. Do you get my point? And what they say, the Arab, deserts, they're called Bedouins. The Bedouins are a tribe and they have a proverb. They say, believe in Allah, but don't forget to tie your camel. Do you get my point? Your camel will run away. So we have what you call as a tremendous amount of entrepreneurship in private happening in this country, and that is why it lifted from 3% to 6.5%, 7%. No sensible economist will deny that. But at the same time, how do I distribute? It's simple. A mother at a home has one son working, one son not working or not able to do. The mother has knows. It doesn't say that one is fed well, another is kept away, right? So it is a role of the government and public policy and constitution. How do I balance these two things? So it is not private versus public interest, right? It is private in alignment with public interest.
So one more question, if you allow. A couple of questions we can take.
Please.
Student Tanmay is asking that right to privacy has gained a significant consumptional recognition recently. How does this evolving rights intersect with the IP rights, especially concerning data protection and trade secrets?
Very simple. India did not have a formal Trade Secrets Act, but we protected it through contracts, whereas the United States has a more clear codification. So there has been a clamoring that why not trade secret also as an act. Government had some multi-stakeholder consultation but they are not still formally come as long as it's effectively managed through contract. So that is one. And second, data protection with the increasing technological intervention and humongous data becomes an asset by itself is what Europe, US has moved. So in India also they think data protection is a very important aspect. But if you talk with privacy, we are talking about a privacy from an individual perspective, and then a privacy in terms of how this data will be played, etc. So naturally, that as the same question arises, the commercial underpinnings of data privacy and trade secrets needs to be definitely safeguarded. Otherwise, you will have no incentive for people to move into this area to unleash their entrepreneurial energy. But at the same time, when it comes to privacy, there are not only government would like to keep a hold, because on totally, if data protection becomes a black box, then you don't know what's going on outside. So this is again, as I said, time to time, a lot of things have to be ironed out. So it's again versus privacy versus data protection is not the question. Data protection protecting certain fundamental concepts of privacy.
Thank you, sir. One more question a student has asked. He was unable to put it on the chat box, so he has sent us on email, sir. He's asking, how does the constitutional right to freedom of speech and expression, that is Article 19(1)(a), interact with copyright law, particularly concerning issue like fair use, parody, and satire? Have there been any significant judicial interpretation in this regard?
They come to the second part. How does it interact with?
How does it the judicial interpretation in this regard? He's asking about the intersection of 19(1)(a), that is freedom of right,
Okay.
freedom of speech and expression, with copyright law, sir.
With copyright law.
Yeah.
Okay.
And
I'm
more
strong.
particularly on
Okay.
fair use.
Okay. Now, or I put it this way: is your freedom of speech where copyright claims should be subservient to that? See, to an extent, what I call as the courts have interpreted vis-a-vis the Western jurisprudence about fair use, fair dealing in education. When you really look, that they allowed the right of expression in a bigger way than what it could be in the Western jurisprudence, which they felt copyright could be subservient to a principle called freedom of expression, which leads to freedom of knowledge seeking and freedom of knowledge gathering. The very case of Oxford, versus the copyright versus the photocopier company in Delhi case, where the judge observed copyright is not a divine law. He said, it is not a divine law means we are interpreting according to the needs of the society. So in that context, I would say that copyright law takes a second step compared to right of freedom. But at the same time, if it is between a commercial motive affecting another commercial motive, right, of misusing a copyright provision or usurping it, and certainly the courts will not apply the same yardstick. It is not the freedom of expression. It is like you get the point. It is not that I take your work and then publish it and then tell that I should be appreciated for it. There, the whole question of private right will play a definite role. But in certain trigger points, like basic education, what should be fair use, fair dealing, I think so far Indian courts, judicial interpretation has been more towards public interest. Or they are telling that freedom of expression interpreted in a different way should allow these things to be accessible. But it is not, again, even 19(1)(a), it's not absolute in many ways. So when you put it in commercial part also, they will tell that publishers do have, what you call it, because of the real logic of investment, and the money they pay to the authors all makes sense for to produce more and more work to bloom in terms of things. So as this is again, I would say that in the concentric circle of protection of IP, the central part is being, you call it as consumer, society, public interest, whatever you call. But there are other circles. The moment the commercial or incentive gets into the center part and consumer public interest get into the peripheral part, we are having a different type of discourse. So till now, I consider it is not peripherally moving, which in my personal opinion, that is the right way to do, especially for a developing country and a country which has to cater almost 1/7 of the population in the world. 1/7 is an Indian in the world population. The remaining 6 put together is 200 plus countries. Of course, you take China out, another 1/7, right? So out of 7 people you stand, 2, one is Indian, one is Chinese. Remaining 5 belong to 200 countries. So certainly our discourse should have a better logic than the discourse of 200 plus who comprise, that kind of population. End of the day, law, logic, everything is not, coming from vacuum. It comes from societal needs and how to move forward.
Correct, sir. So one more question. You already, while in delivering the speech, you already have added this thing that regarding this language conflict and all about cultural rights and inclusivity with the IP laws. The student is asking a question on that, sir. He's asking, do you believe there is a need for more explicit recognition of intellectual property right within the fundamental right chapter or in any part of Indian constitution, perhaps as a form of cultural and intellectual property right? What would be the argument for and against for such move? Like he's asking.
I will strongly recommend fundamental rights should talk intellect. Property part is never what you call as a comfortable thing anywhere. Do you get my point? The word property, do you get my point? We are
Yes.
talking about alienation.
Intellect, yeah.
And neither we have a formula, everybody should get everything. That is a beautiful poet's dream, but not a governance point of view. Every poet will tell everyone should get everything. That is a very lovely romantic imagination, but reality is different. So the question is, scientific temper is important, intellectual way of thinking is important, right? Intellectual way is not only IP, intellectual way is how you treat your compatriot, right? How you treat your somebody around you. How do you treat flora and fauna around you? How do you treat environment is also intellect. So the point, what I am telling, what we are discussing about intellectual property rights is a specific leveraging tool which brings faster innovations and benefit in terms of return on investment. So I consider it should be caged within that framework.
Okay.
Are you getting the point? Beyond that, are you getting the point? Somebody asked me this question long back. One foreign professor asked me, you people don't respect IP laws. I said, no, we do respect. Then he said, no, statistics shows you're not respecting. So I said, your question itself is not correctly framed. I said, in India, we generally don't respect many laws. One is IP law, I said. You get my point? Don't accuse us that we are biased towards IP law. So what I am trying to tell, we are supposed to do many things in other aspects of fundamental right. But why only think IP law? IP should be the fundamental right. If you do other things, I'll tell you, you don't need any great IP law to be protected. Are you getting my point?
Yeah.
Right? Japan has one other high index of innovation. It's also a high index of integrity in public life.
True.
Right? You leave something in a train, it will be there. Without that, what is the point of having an innovation index? So we have a lot of things to concentrate, and automatically IP will become an integral part of many things. That's what I feel.
No, true, sir. So there are, few questions in the list, but I think almost of them are covered in your speech and this question answer forum. So it's time to, offer a vote of thanks on behalf of GLS University.
Yes.
The Constitution of India is not merely a legal document. It is the foundational framework upon which our democratic republic stands. It incorporates the collective vision of our founding fathers and continues to serve as a living instrument of justice, liberty, equality, and fraternity. To uphold its principle is to strengthen the very roots of our nation. To disregard it is to risk the unity and integrity that defines us as an Indians. Today's deliberation have served as a powerful reminder of our duties as a citizen and as a member of an academic community to study, to interpret and preserve the spirit of Constitution with a sincerity and vigilance. We are deeply honored and immensely grateful to Professor Dr. V.C. Vivekananan, Sir, Vice Chancellor, Hidayatullah National Law University, for gracing us with his presence and delivering an inspiring address. Sir, your profound insight have shed light on evolving nature of constitutionalism in India, with including the IP laws and its enduring relevance. Sir, we are very grateful to you for being with us. Our sincere thanks to Dr. Sairam Bhatt, sir, Professor of Law at National School of Law, India, Bangaluru, whose articulation and analysis helped us grasp a constitutional value with clarity and depth. Sir, your patience for the subject is truly recommendable and greatly appreciated. We also express our heartfelt appreciation to Professor Dr. Shilpi Sharma Kaushik ma'am, head of Law Department, Auro University, for sharing her insightful speech and knowledge. Ma'am, your contribution added a significant value to the discourse and enhanced our understanding of contemporary constitutional concern more on residuary powers. We place on record our heartfelt thanks to our powerhouse of Faculty of Law, GLS University, Dr. Mayuri Pandya ma'am, Dean, Faculty of Law, GLS University, for her visionary leadership and constant encouragement in making every event at Faculty of Law a grand success. We are also grateful to Dr. Sneha Sukla ma'am, Vice Director of Faculty of Law, GLS University, for her constant support and valuable guidance throughout the planning and execution of every program that happens on the banner of GLS University Faculty of Law. Our gratitude extends to our teaching and non-teaching staff whose dedication and meticulous planning and coordination ensure the smooth conduct of this event. A final thanks to all our participants. Thanks for your enthusiastic presence and active engagement. Your participation has made this academic discourse all more meaningful. Let us carry forward the insights gained today with a deeper commitment to the value enshrined in our Constitution and continue to contribute meaningfully to its preservation and advancement. Once again, thank you so very much for joining us, Vivekananan sir. Thank you. Thank you so very much.
Thank you. Thank you very much. It's a pleasure
Thank you, sir.
from my side.
Thank you so much, sir.
Thank you.